If you hold a green card or any type of US visa right now, stop everything you're doing and pay attention to what I'm about to tell you. USCIS just dropped an emergency announcement that is sending shockwaves through the entire immigration community, and what's coming in 2026 could completely transform your life in America. I'm not exaggerating when I say this changes everything. Immigration attorneys are scrambling to understand the full implications. Community organizations are flooded with questions, and millions of people who thought their status was secure are suddenly realizing they may have a very narrow window to act before these new rules take effect. Here's what makes this different from every other immigration update you've heard about. This isn't just another policy tweak or a minor adjustment to processing times. What USCIS announced represents a fundamental shift in how the United States will evaluate, monitor, and potentially revoke immigration status for both green card holders and visa holders alike. The rules that kept you safe yesterday may not protect you tomorrow. And the worst part is that most people affected by these changes have absolutely no idea they're coming. So let me ask you something. Do you know exactly how these new 2026 regulations will affect your specific situation? Do you understand which categories of immigrants face the highest risk? Have you taken the necessary steps to protect yourself before the implementation deadline? If you hesitated on any of those questions, you're in the right place. Because over the next few minutes, I'm going to break down everything you need to know in plain, simple language. No legal jargon, no confusing bureaucratic terminology. Just the facts that could mean the difference between keeping your American dream alive and watching it slip away. Now, before we dive into the specifics, let me tell you who absolutely needs to watch this entire video. If you're a lawful permanent resident, whether you received your green card through family sponsorship, employment, the diversity lottery, or any other pathway, these changes directly impact you. If you're currently on an H-1B visa, an L-1 visa, an F-1 student visa, or any temporary work authorization, pay close attention because your path to permanent residency is about to get significantly more complicated. If you're in the process of adjusting your status, if you're waiting for a visa interview, or if you're simply trying to understand what's happening to U.S. immigration in 2026 and beyond, this video was made specifically for you. And if you have family members, friends, or colleagues who hold any type of immigration status, do them a favor and share this video with them. The information I'm about to reveal could genuinely change the trajectory of their lives, and they deserve to know what's coming before it's too late. Let me also be clear about something important. I'm going to give you the facts based on official USCIS announcements and verified government sources. This is not legal advice, and I always recommend consulting with a qualified immigration attorney for your specific situation. But what I can promise you is that by the end of this video, you will understand exactly what changed, who faces the greatest risk, what mistakes could cost you everything, and most importantly, what concrete steps you can take right now to protect your status and your future. Here's what we're covering today. First, I'll explain the specific changes USCIS announced and why they represent such a dramatic departure from previous policy. Second, I'll identify the categories of immigrants who face the highest risk and need to take immediate action. Third, I'll walk you through real scenarios that immigration attorneys are already seeing situations where people made simple mistakes that could now have devastating consequences. Fourth, I'll give you a clear step-by-step action plan that experts recommend you follow starting today. Fifth, I'll debunk the dangerous myths circulating on social media that could lead you to make catastrophic errors. And finally, I'll share insights from immigration professionals about what to expect as these changes roll out and how to stay ahead of the curve. This is going to be comprehensive because you deserve to understand the full picture, but I promise every single minute will be worth your time. So if you haven't already, hit that subscribe button and turn on notifications because immigration policy is evolving rapidly, and I'm committed to keeping you informed every step of the way. Now, let's get into what actually changed and why so many people are calling this the biggest immigration shift in decades. The announcement that has everyone talking came directly from USCIS leadership, and it outlines a complete overhaul of how immigration status will be monitored, verified, and enforced starting in 2026. But to understand why this matters so much, you first need to understand how the system worked before. For years, the immigration system operated with significant gaps in information sharing. Different agencies maintained separate databases. Enforcement was often reactive rather than proactive, and many compliance requirements, while technically on the books, were loosely monitored at best. Green card holders who traveled frequently, visa holders who changed employers, students who took gaps in their studies. All of these situations existed in a system that often lacked the technological infrastructure to catch inconsistencies in real time. That era is officially over. What USCIS announced represents the full implementation of integrated enforcement technology that connects every relevant database, tracks every relevant transaction, and flags every potential violation automatically. We're talking about systems that cross-reference your tax filings with your immigration status. Technology that tracks your physical presence in the United States through multiple data points, algorithms that identify patterns, suggesting you may not be maintaining the requirements of your visa or green card, and most significantly, automated triggers that can initiate review processes without any human decision to investigate. This isn't science fiction. This is happening, and the 2026 implementation date is closer than most people realize. But let me break down exactly what these changes mean in practical terms, because the devil is truly in the details. The first major shift involves what officials are calling enhanced continuous monitoring. Under previous systems, your immigration status was primarily reviewed at specific checkpoints when you entered the country after traveling abroad, when you applied to renew your green card, when you filed for naturalization. Between those checkpoints, there was limited ongoing scrutiny of whether you were actually complying with every requirement of your status. The new framework eliminates that gap entirely. Starting in 2026, your compliance will be monitored continuously through integrated data systems. This means that if you fail to file your taxes on time, the system will know. If you spend more time outside the United States than the guidelines allow, the system will flag it. If you change jobs without proper notification, if you move without updating your address, if you access certain public benefits, all of this information will flow into a centralized monitoring system that evaluates your status in real time. And here's what makes this particularly significant. The system doesn't just flag violations for human review. It can automatically generate consequences. We're talking about automatic holds on benefit applications, automatic flags when you try to re-enter the country, automatic triggers for removal proceedings in the most serious cases. The human discretion that previously provided a buffer between minor mistakes and major consequences is being systematically reduced. The second major change involves dramatically stricter standards for what constitutes abandonment of status. This affects green card holders most directly, but the ripple effects touch everyone in the immigration system. For decades, the conventional wisdom was that green card holders could safely travel outside the United States for trips under 6 months without raising questions. Trips between 6 months and 1 year were riskier but manageable with proper documentation. Only absences exceeding 1 year truly required advance permission through a re-entry permit. The new guidance effectively throws that conventional wisdom out the window. Under the 2026 framework, any pattern of extended or frequent absences can trigger an abandonment inquiry. Officers at ports of entry have been given expanded authority and updated training to question returning residents about their ties to the United States, regardless of how long they were gone. The cumulative time you've spent outside the country over the past 5 years will be calculated and scrutinized. And the burden of proof has shifted dramatically toward the green card holder to demonstrate that the United States is genuinely their permanent home. I want you to understand what this means in real terms. Someone who takes 4 3-month trips abroad per year, each trip technically under the old safe threshold, could now face serious questions because they're spending half their time outside the country. Someone caring for an elderly parent overseas, making multiple extended visits, could return to find their green card challenged, even though each individual trip seemed permissible. The system is now looking at patterns, not just individual events. The third major change involves conditional status holders, and this is where things get particularly intense. If you received your green card through marriage to a U.S. citizen, and your marriage was less than 2 years old at the time, you have a conditional green card. If you obtain permanent residency through certain investment programs, you may also have conditional status. These categories have always faced additional scrutiny, but what's coming in 2026 takes that scrutiny to an entirely different level. The process for removing conditions, which requires filing Form I-751 for marriage-based cases or Form I-829 for investors, will now include mandatory interviews for a much higher percentage of applicants. The documentation requirements have expanded significantly, and the standard for what constitutes sufficient evidence of a genuine marriage or legitimate investment has been raised substantially. Immigration attorneys are already reporting that USCIS is requesting evidence that was never required before. Detailed financial records going back years, extensive documentation of shared life activities, verification from multiple third-party sources, and the processing times have extended dramatically, leaving many conditional residents in limbo for months or even years, while their cases are adjudicated. The fourth change affects visa holders across nearly every category, and it involves what's being called enhanced status verification. If you're on an H-1B, your employer's compliance will be monitored more aggressively than ever before. If you're on an F-1 student visa, your enrollment status, course load, and employment activities will be tracked continuously. If you're on any temporary status, the system will be watching whether you're maintaining every single requirement of that status at all times. What does this mean practically? It means that gaps in employment, even short ones, could trigger status questions. It means that course load reductions for students, even when permitted, could generate flags in the system. It means that the margin for error has collapsed to nearly zero. The flexibility that previously existed in the system, the understanding that life is complicated and sometimes things don't go perfectly according to plan, has been replaced by rigid automated enforcement. Now, I know this sounds overwhelming, and honestly, it should, because what USCIS has announced represents perhaps the most significant tightening of immigration enforcement in modern history. But here's what I need you to understand. Knowledge is protection. And now that you know what's coming, you can prepare for it. So, let's talk about who faces the greatest risk from these changes, because not everyone is equally affected. Understanding your specific risk level is the first step toward protecting yourself. The highest risk category includes conditional green card holders who are approaching their 2-year anniversary. If you received a conditional green card through marriage and you're within the next 12 months of needing to file Form I-751, you need to start preparing immediately. Not next month, not when you get around to it. Right now. The enhanced scrutiny means your petition needs to be bulletproof, with extensive documentation covering every aspect of your marriage. The second highest risk category includes green card holders who travel internationally with any frequency. If your job requires regular travel, if you have family obligations overseas, if you've been spending significant time outside the United States for any reason, you need to reassess your situation immediately. The pattern of your travel over the past several years is going to be evaluated under these new stricter standards. The third highest risk category includes recent arrivals, anyone who received their green card within the past 3 to 5 years. The monitoring systems pay particular attention to newer permanent residents, looking for signs that the status may have been obtained improperly, or that the recipient isn't actually establishing genuine permanent residence in the United States. The fourth high-risk category includes visa holders in transition. If you're on an H-1B waiting for your green card, if you're a student hoping to transition to work authorization, if you're in any temporary status with plans to adjust, these changes create significant new obstacles. The pathway from temporary status to permanent residency is becoming narrower and more treacherous. And the fifth category, one that many people overlook, includes long-term green card holders who have never naturalized. You might think that having your green card for 15 or 20 years provides security, but under the new framework, officers are specifically trained to question why someone has maintained permanent resident status for so long without pursuing citizenship. Extended time as a green card holder, combined with any other concerning factors, can actually increase scrutiny rather than decrease it. Now, let me walk you through some real scenarios that immigration attorneys are encountering right now. These aren't hypothetical situations I invented to scare you. These are actual patterns emerging from cases across the country. Understanding what's going wrong for others can help you avoid the same mistakes. Consider someone we'll call David. David received his green card through employment 5 years ago. He's been a model permanent resident in almost every way. He pays his taxes, maintains steady employment, and has deep ties to his community. But David's mother became seriously ill overseas, and over the past 2 years, he made multiple trips to care for her. 4 trips total, each lasting between 2 and 4 months. He never exceeded 6 months on any single trip, so he assumed he was safe. When David returned from his most recent trip, he was pulled into secondary inspection for the first time ever. Officers calculated that he had spent nearly 10 months of the past 24 outside the United States. They questioned him extensively about where he really lived, where his true home was, why he was spending so much time abroad. David had his green card physically taken from him and was given a notice to appear before an immigration judge to determine whether he had abandoned his permanent residency. David did nothing malicious. He was caring for his dying mother. But under the new enforcement paradigm, compassionate circumstances don't automatically translate to protection. David is now spending thousands of dollars on legal fees, fighting to keep the status he's held for years. Consider another situation involving someone we'll call Priya. Priya came to the United States on a student visa, completed her degree, transitioned to H-1B status, and eventually received her green card through her employer. She's been a permanent resident for 3 years. What Priya didn't realize is that when she briefly lost her job 2 years ago during company layoffs, she should have been more careful about documenting her situation. Priya was unemployed for 4 months before finding a new position. During that time, she didn't file any special documentation with us because she didn't know she was supposed to. She continued living in the United States, continued looking for work, and eventually secured an even better job than before. Problem solved, she thought. But when Priya recently applied for naturalization, the new integrated systems flagged her employment gap. Officers questioned whether she had violated the terms of her status during those 4 months. They asked for extensive documentation proving she was actively seeking employment and not relying on public assistance. Priya's naturalization application is now delayed indefinitely, while she tries to reconstruct evidence from a period she barely remembers. Here's another scenario involving a married couple. Let's call them James and Maria. Maria came to the United States and married James, a U.S. citizen. They filed for Maria's green card, went through the interview, and Maria received her conditional permanent residency. Everything seemed perfect, but life got complicated. James lost his job. They had to move to a cheaper apartment. Financial stress created tension in their marriage. When the time came to file Form Y-7551 to remove the conditions on Maria's green card, they were still married but struggling. They had fewer joint assets than before. They were living more separate financial lives out of necessity. Their documentation of shared life had gaps because they were simply trying to survive. Under the new enhanced scrutiny standards, their I-751 petition was flagged for an interview. Officers questioned the legitimacy of their marriage. They asked probing questions about why their financial lives weren't more intertwined. They requested additional evidence that the couple struggled to provide. Maria's conditional status expired while the case was pending, and now she's technically out of status, unable to work legally while they wait for a decision that could go either way. These scenarios illustrate something crucial. The new enforcement environment doesn't distinguish between intentional violations and innocent mistakes. The system flags discrepancies and inconsistencies automatically. It's up to you to prove you've done nothing wrong, and that burden of proof has become substantially heavier. So, what should you actually do to protect yourself? Let me give you a concrete action plan based on what immigration experts are recommending right now. Step 1 is to conduct a complete status audit immediately. Pull out every immigration document you have: your green card, your visa stamps, your approval notices, your employment authorization cards. Check every expiration date. Verify that all the information is accurate. Create a timeline of every trip you've taken outside the United States in the past 5 years. Calculate exactly how many days you've been abroad. If you see any gaps, inconsistencies, or concerns, note them now before the system flags them for you. Step 2 is to verify and update your address with USCIS. This sounds simple, but an astonishing number of people fail to do it. Immigration law requires you to report any address change within 10 days of moving. If you've moved and haven't filed Form AR11, do it immediately. This is free and takes only minutes online, but failing to do it can be used as evidence that you're not following the rules, which can compound other issues. Step 3 is to build a comprehensive evidence file demonstrating your ties to the United States. This includes your lease or mortgage documents, utility bills in your name, employment records and pay stubs, tax returns for every year you've held your status, bank statements showing U.S. financial accounts, vehicle registrations, membership records, children's school enrollment documents, anything that proves this is genuinely your permanent home. Don't wait until you need this evidence to gather it. Start building this file today. Step 4 is to get current on all tax obligations immediately. If you've missed filing any returns, work with a tax professional to file them now. If you owe money, set up a payment plan. The integration between IRS databases and immigration systems means that tax problems will surface during immigration proceedings. It's far better to address these issues proactively than to have them discovered during a status review. Step 5 is to consult with a qualified immigration attorney if you have any questions about your situation. I cannot stress this enough. The complexity of these new regulations means that generic advice can only take you so far. If you've traveled extensively, if you have employment gaps, if you're approaching any deadline for filing, if anything about your situation feels uncertain, invest in professional guidance now. A single consultation could identify issues you didn't know existed and save you from consequences you never anticipated. Step 6 is specifically for conditional green card holders. Start preparing your I-751 or I-829 petition months before your deadline. Gather evidence systematically. Document your genuine marriage or investment thoroughly. Photograph your life together. Collect affidavit from friends and family who can verify your relationship. The stronger your evidence package, the less likely you'll face problems during adjudication. Step 7 is to stay informed about ongoing changes. Subscribe to official USCIS updates. Follow credible immigration news sources. What I've shared today represents current announcements, but this landscape continues to evolve. Being informed is your first line of defense. Now, I want to leave you with something important. Everything I've told you today might sound frightening, and honestly, these changes are serious. But here's the truth that matters most. The vast majority of people who follow the rules, maintain genuine ties to the United States, stay compliant with their obligations, and document their lives properly will navigate these changes successfully. This isn't about fear. It's about preparation. It's about understanding the new reality and adapting to it intelligently. You now have information that most people in your situation don't have. Use it wisely. If this video helped you understand what's coming and how to protect yourself, hit that like button right now. Subscribe and turn on notifications so you never miss critical updates. Share this with anyone you know who holds a green card or visa. And drop your questions in the comments below because I read every single one. Stay informed, stay prepared, stay confident. You've got this.